Hey, welcome to Holmquist and Gardner quarterly webinar. Very excited to have you all here today. And we are excited to cover a topic that we haven't spent a bunch of time on as it's a new practice area for our firm, estate planning. We are delighted to have already given a webinar focusing mostly on taxable estates. Today, of course, we'll talk about more of the general estate planning and basics for a simple estate or a non-taxable estate. Joe Bell in the background, our PR person, has helped us put together this wonderful PowerPoint. She's going to move the slide forward for me, and you might hear me directing her around from time to time. So moving to the next slide, we are happy to have everyone here. We remind everybody that this is being recorded, so you'll see a link that you can spread to your friends to our YouTube channel. But this is strictly for informational purposes. We want to give an overview of some things to consider and understand so that you know what you have and what you don't have, what you may want to do in the future. It is not a substitute for a legal review, and we would advise you to seek legal counsel on your particular matter and have an attorney review facts, the law, and put together a course of action for your estate plan as necessary. Of course, that may be us here at Holmquist and Gardner or some other attorney. In any event, this is for informational purposes. I hope you enjoyed the program. Holmquist and Gardner, next slide, is a 8-attorney law firm. We do business and real estate, construction, employment, and estate planning work. We have a litigation team and a transactions team, so we're able to enforce our agreements and make sure that our clients are taken care of in a holistic manner. We really pride ourselves on being efficient and having the technology to move quickly with new clients, new client setup, new client intake, and we believe we're at the cutting edge of that. So with that, we will move on to the next slide. During the presentation, you'll have questions. That's great. We may be able to answer them on the fly. We're looking at maybe 20, 25 minutes of content here. There'll be time for some Q&A afterwards. If we don't answer your question, of course, we'll try to get to you offline, or you can email us. Contact information is available as each of us speak. You can see it in the video. It's kind of cool. Thanks, Joe Bell, for that. No bow tie for me today. Write it down. Unusual, but there it is. So with us today, we have Grayson Chester, the newest attorney at Holmquist and Gardner. Grayson has 5 years of estate planning practice under his belt, and it's handled primarily taxable estates, but we also handle basic estates. And we'll talk about what the thresholds are and things to consider for that. Next slide, please, Joe Bell. As we move through today's presentation, Estate Planning 101, again, high-level overview. There's, of course, a lot that we could talk about, and I know Grayson can talk for hours about it because he's quite passionate about this, which is why we brought him on board. But we are not going to go so far into depth that we're putting you to sleep. We are going to cover why you might want an estate plan, the basic documents, and then how to know whether to update those documents. If you did them a long time ago, what are sort of the things to look out for, perhaps adding a codicil or updating your documents altogether. So with that, I'm going to turn it over to Grayson, and I'll be here and may interject with some comments or thoughts, but I'm like, Grayson, take it away with that. Grayson Chester, thank you very much for joining us today.
Wonderful. Thank you for introducing me, Imants, and thank you very much to all of the members of the audience here for being with us today on this relatively bright and sunny Wednesday afternoon. We don't get too many of these here in Seattle, so I appreciate very much that you'd be willing to spend this time with us. As Imants mentioned here, we're going to be talking about estate planning today, wills, trusts, estate, death, dying, taxes, of course, but I'd like to try to keep this as basic as we can. We're going to hit the low-hanging fruit material that tends to apply to the most amount of people, the estate planning for the 99%, for lack of a better term. Let's move on to the next slide here. So before I get into the nuts and bolts of estate planning, I want to make sure we've all arrived here for the same or similar reasons. What is estate planning? Why would someone plan here to have an estate plan? And so I want to make sure we're all on the same page that estate planning is practical, and what we're trying to achieve is peace of mind. What we're planning around here is death, yes, but it's not the only thing. There's actually two areas that we are trying to grapple with, that we're thinking about. And death has been the longest one of these, but nowadays, that second item is actually incapacity. And because incapacity happens during life rather than death, incapacity is usually the one that we see first, especially here in Washington, where we are a very, very healthy state, all things considered, but where our mental health is relatively average. And that means that Washington residents, more so than residents in almost any other state nowadays, have a much higher likelihood of ending their life in a period of incapacity, meaning that incapacity planning now is just as much a part of estate planning as the actual death planning side is. Now, before I move on, I want to mention something here very important about minor children. Now, as parents, folks have had to consider who might be taking care of their minor children if they've passed away for many, many, many centuries, millennia now. Just as big of an issue, I should say, has been more recently, what happens if it's not death that takes us out, but rather incapacity? What if it's for a coma or a medical reason, for some other incapacity reason, that we can no longer serve in the role of making decisions for our own minor children? And so this question of who would serve as that child's guardian is not just a death planning issue now, it's also a life planning issue. So we're going to see when we talk here through some of the planning tools available for us for incapacity planning and in death planning, minor children are an item that should be thought of in both, because we don't know which of those, if any, would potentially take you out. Let's move on here. We're going to go to the next slide. And I want to give a little bit of finality here to answer that question of why make a plan? Well, there already is a plan here for you for both incapacity and death. If you do not make a plan for yourself, the state has one for you. For incapacity, if you were to find yourself in a position where you did not have the mental wherewithal to understand what was going on around you, to make financial decisions, to make medical decisions for yourself, that would require a court process. And that court process is particularly burdensome, not just in terms of cost and time, but also in the amount of fact-finding and how invasive it is. Think about being in that position, maybe not being able to recognize your own family members, now having a court-appointed representative come to your home to ask you a tremendous amount of very, very probing, detailed, personal, intimate questions to ascertain first whether you even need this guardianship. The second part of this is to determine who your guardian should be. And depending on who you are, you're probably thinking correctly generally that it would be a spouse or a child or a parent, somewhere on that list of priority, but that's not automatic. That's a court process, right? That's still part of the guardianship process, because the court wants to make sure that they are not going to be empowering your abuser, that they are putting the right person in this position of guardian to serve here for you. The next and most burdensome part is that each year thereafter, that guardian has to report back to that court every single year for every dollar that came into your name, and every dollar that came out, any major healthcare or financial decisions. And that amount of cost here starts to snowball very, very radically. The reason for all of this burden is frankly because if we end up in this type of situation, the state is concerned about us. They are less concerned about whether there would be a pile of money left over for our heirs. And so if a guardianship process costs $50,000+, that's okay, so says the state, at least you were taken care of. Now, the plan that the state has for you at death is called intestacy. This means to die without a plan. And in that case, you have a probate, but not really any old probate. Probate's quite common. In this case, you have a probate where all of the questions are left unanswered. The court would want to make darn sure that they knew who they were appointing to be the one in charge of your estate. And they may want to actually monitor that person along the way. They may want to have court intervention. They may want that person to have to go buy an insurance policy to get bonded effectively to insure against their own bad behavior. And so this type of probate, this court process to do intestacy, just the procedure tends to be a lot more burdensome. The other big problem here with intestacy is that the state is simply guessing as far as who you might want to benefit in the event of your death. Obviously, children and spouses are on that list, right? But if you have a minor child or a child with special needs, or maybe children from other relationships, well, the law is not all that great at figuring out all of those personal, intimate details in your life that might suggest something like, say, holding assets in trust for someone's benefit, or making sure that things are protected for someone's creditors, or against DSHS, Medicaid, Social Security Administration. There's a tremendous amount of complexity that people often have in their lives, and intestacy does not address any of those factors. I'm going to leave this note here with one final comment, which is charities, causes, the legacies that we want to leave for our own family, for the world that we leave behind. None of those are going to happen if we have no plan. We have to actually have a plan and say so ourselves, because the law will not ever gap fill that for us. Let's move on to the next slide. Now, we're going to talk here about some basic estate planning documents. And as you may already be aware, there's a tremendous amount of legal jargon here, lots of different names for lots of different instruments. And as I mentioned earlier, I'm going to try to keep this pretty darn simple for you all. So we're going to start here with incapacity planning. And the chief tools that we use to plan for incapacity are powers of attorney. They are very, very simple to put in place. They're usually a few $100s in an attorney's office. And a power of attorney document simply says, in effect, if you were to ever become incapacitated, this is the person that you would want to serve for you, not as a guardian, but as your agent under power of attorney. And that is not a court process, not in most cases. They usually, these documents, these powers of attorney, go one step further or two steps further, and they'll say, if that person can't serve for me, then this is the successor, this is my backup. And ideally, we would even have a backup to a backup. I like to see 3 names in my documents. 4 is even better, but if I see 3 names, I start to feel pretty secure that if that first person can't serve for us, it's not like we don't have a plan. There's a backup, and there's a backup to that backup as well. Now, powers of attorney tend to be divided into 2 different buckets. And nowadays, we're actually talking about 2 different legal documents, even though they're governed under the same law. There's your financial concerns, right? Who's going to pay the bills for you? Who's going to file your taxes? Who's going to pay the property tax, pay the mortgage, right? Who's going to take income in your name? Then there's also the healthcare concerns, right? Who's going to be making healthcare decisions for you about certain elective treatments, or whether they may operate for this particular ailment, whether this type of medication or that type of medication would be best for you. And so we started to realize about 20 odd years ago, and it's gotten a lot more common sense, that it's best to keep these 2 documents separate. We may not have the same person in our life that we trust to serve for financial concerns as we would trust to serve for healthcare concerns. And of course, we can absolutely name 2 different agents, one for finance and a different one for healthcare. Now, the other document here I'm going to mention dealing with incapacity protection is the Advance Directive to Physicians. This is an end of life planning document, but it is still a life planning document. You'll often hear these called living wills. They are not wills. They do not come into being at death. They are documents here dealing with 2 end-of-life concerns, the first of which is death is imminent. This means hours or days away from death, no more than 72 hours of life ahead of you. The second condition is the permanent unconscious condition. This is not just dementia or Alzheimer's, unable to recognize your family members. We're actually talking about having no meaningful response to the people or the environment around you. Now, in these cases, either of these situations, we are allowed, and it's a very good idea to do so, to have authorizations to say, what is it that you would want to have happen if you ever ended up in this type of position? Simply saying so in this legally binding document that your healthcare agent under the power of attorney can use to support your wishes provides a tremendous amount of clarity and a tremendous amount of peace of mind, not just for yourself, but also for your family. Now, I'm going to mention as well one final document, which is a HIPAA authorization. Most powers of attorney have an authorization in them. It says that your agents can access medical records, but nowadays, just for these emergency situations, I tend to find it's a good idea to have a standalone document belt and suspenders, yes, but a separate HIPAA authorization document that says, these are the people who can actually access my medical records. Does no one any good if people can make decisions, but in all the fumbling around, they couldn't actually get the medical records to be able to make those decisions with. Now, here's the first place we're going to see in powers of attorney. This is where we first nominate our guardians for minor children. If it's not death that takes us out, if it's incapacity, if we haven't died yet, then it's our incapacity planning that we are going to use to appoint those guardians. Okay, let's move on talking about the basic documents here for the death planning side. Now, many people have already heard of wills and trusts before, and yes, that's exactly what we're going to go through. But before I talk about those more advanced documents, I always start with beneficiary designations. Because when we die, frequently here, our assets themselves will actually answer the question as far as where do they go when we pass away. We call these pay on death accounts or transfer on death accounts. We even have transfer on death deeds. Oftentimes we have joint accounts that are held joint tenants with right of survivorship. Most joint accounts are like that, but don't assume. There's lots of different ways for two names to be on an account. All this is to say that if the original owner or one of those original owners dies, it means that that next name gets this account instantly. Well, you have to show a death certificate, but without a court process to get it there. It's probate avoidance. It's a very, very attractive tool to carve off an asset or two to go to the person or people that you would want it to go to. The problem with beneficiary designations is that they can only go one way, outright. Unless you have something more substantial like a will or a trust, you would never be able to leave these types of assets to minor kids in a way that would be protected from them for their college or their medical expenses, right, until they hit a certain age. So it doesn't take a lot, and most people have one or two of these issues already, for beneficiary designations alone to be an unsuccessful estate plan. Usually we talk about having beneficiary designations plus something more substantial. And this document for most people is the will. The will is what would govern anything else, most assets in most cases here, that have not been beneficiary designated. And wills are designed to be very, very simple to put in place, but there's a process to administer them. And that process is probate. Wills go through probate. And please don't mistake this point, because a lot of people get confused on this. They think, well, if I don't have a will, I go through probate. But if I have a will, I also go through probate. Well, that's exactly right. The will, however, simplifies that process. In the will, it appoints the person that you would want to serve for your personal representative, for your executor. And it says, ideally a good will would say this, that you would want that person to serve without the court oversight, without the court intervention looking down. That causes a lot of cost. And we also generally would ask that there would be no bond forced upon that personal representative. This makes that probate process a lot simpler, a lot cleaner, and leaves fewer people guessing about what it is that you want. Just as importantly, your beneficiaries are provided for, and they're provided for in the ways that you want them to be provided for. If you have a special needs child that you need to hold these assets for in such a way that doesn't disqualify them from SSI or from Medicaid, we need to do something a little bit more complicated than could be done in a beneficiary designation. And if that is a little bit of a probate, that's not the end of the world at all. Now, I'm going to mention here, before I move on, that there's another estate planning tool that people often use as a replacement for a will called a revocable living trust. These tools tend to be a little bit more sophisticated. They require a little bit more management during life. They require the trust actually be properly funded. That means assets put into the trust. Every asset you own properly coordinated with that trust. Otherwise, it does not do much good. And what is that good, you might ask? Well, a properly funded living trust is supposed to avoid probate. And when it's done right, that ends up being very, very successful. For now, though, most folks who start with estate planning tend to start with wills because they are a lot simpler to understand, they're a lot easier to put in place, and they're a lot simpler to keep up to date with major changes in our life. On that note, let's go to the next slide, and we're going to talk about updating our estate planning over the years. Now, as a general rule of thumb, I think it's a very good idea to get in the habit of speaking to your attorney on a routine basis about updating your estate planning instruments. That doesn't mean that you need to update them, but you should speak to your attorney and see whether they do need to be updated. Again, as a general rule of thumb, we want to put a nice firm number on that. I like to see every 4 to 6 years or any major life event. Birth, marriage, divorce, death, adoption, etc. That could be to you, to a loved one, a beneficiary, right? Any of these big items here, or simply the passage of time alone, would suggest let's revisit your estate plan. And I want to show you here, there are 3 big areas for things to shake loose over time. And when we're talking about someone who has more than 5 years ahead of them, odds are there's more than one of these changes that's going to happen. So accounting for these changes is very, very important. The first set of changes here are personal changes. These are changes in your family. This could be new or lost family members. They could be different relationships, right? Different belief systems, goals, right? They could also here, the next set of changes, be changes in your finances. We're talking about big increases in your net worth, but also big investment changes. If a few years ago, you were a high-flying business manager with running your real estate investment business, and you've since cashed out, and now all of that value is held in an investment account. Well, that's a big life change that I would think would be a good idea to come in and talk to your estate planning attorney about making sure your estate plan is properly up to date. The third and final area, probably the scariest one here, which I always want to mention, is changes in the law. Over the last 20 odd years, there have been an alarming number of changes in the law, not just federal law, but state law too, which have suggested in many different instances for people to update their documents just to account for changes, which, let's be honest here, folks, most non-lawyers are going to have a very, very hard time spotting. So just for the passage of time alone, I would suggest that you come in and speak to an attorney, because the attorney is going to be able to tell you whether there have been any major tax law or estate and trust law changes which have radically implicated your plan. I'll tell you right now, since 2017, there have been 3 or 4 major law changes that I tend to look out for in my clients' documents to make sure that those changes have been accounted for. Let's move on to the next slide here. And I wanted to part ways by giving you all a very, very quick, brief glance at when we start to be concerned about estate taxes here in Washington. Now, estate taxes are transfer taxes. They're taxes at death on the privilege, we'll say, that's the state tax regime's term, of leaving assets to a non-spouse or a non-charity. And so there's a federal estate tax, and that federal estate tax, as of this year, hits on all net worth over $12,920,000. That's nearly $13 million. So forgive me, I'm going to round upward. And that's a very, very easy number to double for married couples without a lot of difficulty. You can actually double that number so that it's actually closer to 26 million before we really need to be thinking about any real tremendously complicated federal estate tax planning. But in Washington specifically, we have another estate tax. We have a state estate tax, and that state estate tax is only $2,193,000. There is, if you are curious, a bill right now in the legislature to raise that to some 2.5 million adjusted for inflation. It hasn't passed yet, and this would not be the first failed attempt if it were to fail. So I mention it, but for now, we're looking at just about $2.2 million before we start to be concerned about maybe there being a tax cost here. The other big issue here in Washington is that unlike the federal estate tax exemptions, it is very, very hard to double these for married couples. In effect, a married couple is probably going to share one single exemption, not 2 exemptions, unless they engage in more sufficient planning. Now, the federal estate tax rate is 40%. The Washington state estate tax rate is actually the highest of all states in the country at 10 to 20%. And so as a general rule of thumb here, I would encourage anyone whose net worth is starting to approach $2 million, including your house, including your IRAs, your tax qualified accounts, and including the death benefit of your life insurance. Anyone in that position should consider engaging in a little bit more sophisticated tax planning for these estate tax transfer liabilities that might be waiting. On that note here, I'm going to turn this over to Imants, and he's going to field questions.
Yeah, thank you so much, Grayson. That was extremely helpful. At this point, we'll look through a few of these questions here and try and cover them. And if we don't get to your question, by all means, our email address is right here in our little thing, imants@lawhg.net and grayson@lawhg.net. The first one, just to be clear on what that taxable number means, if you're just a hypothetical husband and wife worth $5 million, let's just, or we'll call it, yeah, $5 million, and you both pass together and you have no taxable estate plan, you just have a will and it's all going to your kids, you're saying that then approximately, what is that math, 2.9 million, or I guess that's 2.1, 2 plus million, close to 3 million becomes taxable at 10 to 20%. That's 100 to what I mean.
So the way the brackets work on this, it ends up making it so that that value is a little bit over $300,000 of tax liability. Right. So a married couple should be able to protect at least 4.4 million. That's 2.2 times 2. If each of you get 2.2, you should be able to double it. But the reality in Washington is that most married couples really only get one. If one spouse passes and leaves the whole married pot to the survivor has their half and the half that was left to them. But they only have their one Washington exemption. The first person's exemption was wasted. You cannot leave that exemption to the survivor, not in Washington.
I've had a question here. What happens if we have all the documents, we're working with an attorney, and then somebody passes away before they get executed? This is one of the rare questions I can answer. You need to actually have everything fully executed. Unlike other contracts where the Berg v. Ting context rule would apply, where you could actually get the intent of the parties and try and use that in court to demonstrate what's happening. If you do not properly execute your estate planning documents, they're not binding. And whatever your previous plan was, there is what will happen. And that is a very unfortunate situation that there's plenty of case law out there has actually happened. So if you are thinking about making a change, you need to put that in place. No expression of intent that's not compliant with the law is going to function.
I'm going to go one step further on that, actually, and I'm going to say that there's a good number of documents, wills and trusts specifically, in which it's not just a requirement that they be legally executed. You actually have to have the original as well. It's not true in all estate planning documents, but that actual wet ink original, ideally even in blue ink, is a very, very important physical item to have now.
Yeah, and I would also note, just as a practice matter, this concept of having having two or more different people handling different areas of the estate as you designate that is a little bit different than what the state will leave you with if you don't have documents. And so I think most people, I mean, maybe not all, but most people would say, I want this person or couple being the guardians of my children, but I want this other party to be the one that's really going to control the purse strings for how those funds get dispersed to those kids, or at least helping make decisions for those kids. And if you don't have documents in place, then it's typically just going to be all or nothing. It'll be all one person handling all of it, which may or may not be the best situation. I have a question here. If your will states that assets go to a trust for a minor, who sets up the trust? Good question for you, Grayson.
That's a great question. So if you have a will that says that these assets here, whatever they may be, are supposed to go into a trust for a minor, remember, that's not going to happen until you pass away. So I'll tell you right now, the one person on earth who could not set that up is you. However, your will is almost certainly going to say in it, this is the person or people that we would want to serve as personal representative. And unless you have specified something differently, it's going to be that personal representative, the one who's administering your will, who would take the extra step now to set up that trust. And this really looks very, very simple. It's an application to the IRS for a tax EIN number and a single page notice to that beneficiary of the existence of that trust.
Then we have another question. I previously had a comprehensive estate plan prepared about 10 years ago involving various trusts and a dynasty trust. No major changes since then, other than retirement, but I want to have the whole plan reviewed in light of tax changes in the past decade. How would you handle the review and or recommendations of my estate plan?
Imants, would you like to field that one?
Sure. So essentially, we have two main avenues here at Holmquist and Gardner for reviewing those, and I think they're fairly similar to most places, but we like to try to streamline it. It may be that a simple review of your estate planning documents to see whether they're compliant is a great place to start, and we may handle that hourly or may not, depending on the circumstances. If the estate plan is old enough, I mean, typically we treat it as a new estate and have you complete a estate planning questionnaire outlining your assets. And then Grayson would spend time looking at that and advising, or at least providing a plan that would be a plan that you could either move forward with or not. And typically that process is something that we do on a consultation basis. And so the first step in that process is emailing us, and we will get you an intake form for a conflict check. But that's how we would approach it. And Grayson, want to add anything to that?
Yeah, I'm going to mention here, just so you're aware and the audience is aware as well, that dynastic planning, that more generally I would see that as being to hold assets for the next generation, and then when they pass, for those assets to go down to the subsequent generation, is one of the more complicated areas here in tax law. The federal government has invented not one, but a couple of different more fancy taxes to deal with these types of setups. And so reviewing these trust instruments is not just a question of estate tax, but also things like generation skipping transfer taxes and even income tax step-up concerns as well. All that is to say that we could certainly review that document, but we'd like to generally take a look and see what it is first that we're talking about.
We do apply the same principles that we apply to our other practice areas, where we try to keep things simple. If there's no need to touch something and change it around, we won't do that. If it's in fact something that should just be, it's more efficient to just start from scratch, we'll do that. We're very flexible in our approach, and we typically are not going to, at least from the beginning, inception of a matter, charge a fee to just get to a point where we understand what the action items are. It's a little bit different if you come and say, hey, I've got multiple trusts set up and I want to change this or that, and I know in advance that's what I want to do. Obviously, we would probably consider that on some kind of hourly rate, but every client is different, and the best way to discuss this would be to email us and get started with a potential relationship. A few more points. The changes in the law piece is something that we see across the board in real estate, business law, corporate documents set up a while ago. It's become more and more common that the statutes have been updated and things were formed or created in the 90s. You have statutory citations that now are not just misleading, they just lead to an incorrect or inaccurate result. In a dynastic trust situation from years ago, I would say that we would almost sit here and say, yeah, there's probably some things in there that have changed. And we've had a few where there are material differences, and it's unfortunate because the time we're looking at it, sometimes it's past the point of no return. So urge everyone to get their docs finalized, seek counsel. Really appreciate you attending this. If you found this interesting and helpful, go ahead and share the link that you'll be receiving via email to the recorded version of this with your friends and family and colleagues. And if you're watching this at some point in the future, this is being recorded in 2023. There may be statutory changes, although we didn't get that far in depth. So just reflect the law does change and our policies change. You'll see an email from us with a link to the video. And if you have any questions, our contact information is here. And thank you all for attending. Thanks, Grayson.
Thank you very much, Imants, and thank you very much, everyone else, for being here with us today. Have a great day.